Well, Jussie Smollett is back in the news, and some of the arguments raised in his most recent court filing are not going to go over well, not in court and not in the court of public opinion. Viva Frei, Montreal litigator turned YouTuber, vlogging at you from my kitchen because my wife has
taken my office for the day.
Now, many of you probably know that Jussie Smollett is back in the news because his bid to have the new charges against him dismissed on the basis of double jeopardy was itself rejected by a Cook County judge. If there's anybody out there actually watching this vlog who doesn't know who Jussie Smollett is or what he did to land himself into the never-ending judicial saga, no 30,000-foot overview. I'm just going to link a playlist to all of my Jussie Smollett vlogs right here. Give them a watch if you, for some reason, don't know who Jussie Smollett is or what he did. By now, all of you know that the original 16 charges against Jussie Smollett were dropped. A new special prosecutor was appointed to the file who pressed new charges against Jussie Smollett. Jussie Smollett made a request to have those new charges thrown out on the basis of double jeopardy, and that request has failed. In reading all of the articles on the subject, I noticed that every single article was referencing the exact same quote, and I mean every single article, and I mean the exact same quote. From the Chicago Sun-Times, judge says new charges against Jussie Smollett, not double jeopardy. Quote, there was no trial in this case. There was no jury impaneled. No witnesses were sworn. No evidence was heard. No guilty pleas were ever entered. Nothing like that ever happened, Lynn said of the 2019 case. There was no adjudication of this case. Not only does every article reproduce the exact same quote with no link to the actual order, they reproduce the exact same typo from the Federalist News Network. There was no trial in this case. There was no jury impaneled. No witnesses were sworn. No evidence was heard. No guilty pleas were ever entered. Nothing like that ever happened. From the Washington Post. Nothing like that ever happened. Law and Crime was exceptional because they reproduced the same quote, but they actually corrected the typo. Come to think of it, to the extent that it's probably a syndicated news piece, I wonder if they're going to get in trouble for altering it. Law and Crime. Nothing like that ever happened, Judge James Lynn said, according to the Chicago Sun-Times. Reading the articles, I began to realize that I didn't fully understand the concept of double jeopardy. I mean, I saw the movie Double Jeopardy. Oh, who's this? Who is this? Is my mother?
It is my mother.
I saw the movie Double Jeopardy, but that was over 20 years ago, and I don't remember a thing of what that movie was about. We all pretty much understand the most basic concept of double jeopardy, which is that you cannot be prosecuted or punished for the same crime twice, but it's a little bit more complicated than that. The concept of double jeopardy comes from the Fifth Amendment to the United States Constitution, which reads as follows. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. And according to Wikipedia, the 4 essential protections included are prohibitions against, for the same offense, retrial after an acquittal, retrial after a conviction, retrial after certain mistrials, and multiple punishments. Jeopardy attaches in jury trial when the jury is impaneled and sworn in a bench trial when the court begins to hear evidence after the first witness is sworn in, or when a court accepts a defendant's plea unconditionally. If you're anything like me, you're hearing this word attach and asking what it means. It's the legalese concept of applying. Double jeopardy attaches upon certain conditions. And surprisingly, or possibly not surprisingly because we're talking about the law, the idea of when someone is twice put in jeopardy of life or limb for the same offense is not cut and dry. According to the Fully Informed Jury Association, jury duty is for heroes. We might consider ourselves in jeopardy of life and limb when a police officer points a gun at or shoots us, tasers us, tackles us, and pins us painfully to the ground with a boot on our back, handcuffs us and imprisons us, etc. None of those things, however, are considered in the American legal system to put us in jeopardy for purposes of the Fifth Amendment prohibition against double jeopardy. Neither does being indicted or charged put us in such jeopardy according to the courts. Neither does being held in pretrial detention without bond. Neither does being brought into pretrial hearings or even selecting a jury, quote, start the clock, so to speak, on jeopardy. Jeopardy attaches at different legal times depending on what route a case takes through the legal system. Trial by jury, bench trial, plea bargain, or juvenile proceedings. In a trial by jury, the rule is that jeopardy attaches when a jury is sworn. So given this cursory overview of the concept of double jeopardy, we can sort of make more sense of the quote from the judge, and we can sort of see why Jussie Smollett really stood no chance of succeeding on his request. The concept of double jeopardy, however, was not the sole purpose of this vlog. In the context of the City of Chicago's lawsuit against Jussie Smollett just filed a document entitled Defendant Jussie Smollett's Reply in Support of Motion to Compel Production of Documents. The City of Chicago is suing Jussie Smollett to recoup the costs of the investigation associated with his allegedly false police report. In the context of that lawsuit, Jussie Smollett counterclaimed for malicious prosecution, but his counterclaim for malicious prosecution was itself dismissed. Jussie Smollett is now defendant to the City of Chicago's lawsuit, and he is defending himself vigorously. And as we've discussed in previous vlogs, Jussie Smollett basically wants to investigate the investigators. He wants a whole slew of documentation relating to everyone and anyone who's involved in his investigation. Apparently, the City of Chicago is holding out communicating certain documents. Jussie Smollett doesn't like it, and he is insisting on communication of those documents, and this is his reply to the city's opposition. And wait until you read the first paragraph. Introduction. As we see millions across the country rise up to protest and expose police misconduct, the city, by its refusal to produce the requested documents, is choosing to actively resist a citizen's lawful efforts to reveal dishonesty directly relating to the charges against him throughout the department, including the police superintendent who oversaw and publicly commented on the investigation of Mr. Smollett's report of a vicious hate crime and assault. In any court file where the proceedings are public, you are going to have two separate courts. You're going to have the court of law and you're going to have the court of public opinion, and something tells me that neither of those two courts are really going to appreciate what Jussie Smollett is alleging right here. As we have in fact seen, there have tragically been true victims of police misconduct, and I don't think a court or the general public is going to believe that Jussie Smollett is one of those victims. In my humble opinion, it's a terrible and discrediting way to start this brief, because despite all the flaws of Jussie Smollett's situation, the argument brief itself does raise legitimate arguments and should not have started with this offensive comparison. Indeed, the city's opposition to the motion to compel puts the cart before the horse and largely fails to appreciate that this case remains in the discovery phase. Allegations are not proven facts, but the city improperly assumes that it has already proven that Mr. Smollett made false statements to the CPD. And this is in fact true, despite how we, members of the jury of the Court of Public Opinion, might be thoroughly convinced of Jussie Smollett's guilt. The city of Chicago still has to prove their case. The allegations in the city of Chicago's lawsuits are just that, allegations. They are not proven fact, and to the extent that they are allegations, Jussie Smollett has the right to defend himself against those allegations. And that right to defend gives him the right to discover certain documents that he thinks might be useful to his defense against those allegations. As frustrating as that might be when you are already thoroughly convinced of his guilt, that is the law and that is how it works. Relatedly, by stating, quote, Smollett is on trial, not Eddie Johnson, as a premise to oppose the motion to compel, the city improperly seeks to narrow the scope of discoverable information. Importantly, there is no dispute that former Chicago Police Department Superintendent Eddie Johnson was involved in the investigation of the January 29, 2019 attack on Mr. Smollett. Former CPD Superintendent Eddie Johnson, and we know that Eddie Johnson was involved in the investigation and that he no longer works for the CPD.
And the plot thickens.
You may recall that Eddie Johnson made a number of public statements about the investigation. The fact that he has now been fired, you know Jussie Smollett is going to jump all over that. In discovery, the basis for Chicago Mayor Lori Lightfoot's decision to fire Johnson because he, quote, intentionally misled the people of Chicago and he intentionally misled her is directly probative of Johnson's credibility and will inform Mr. Smollett's defense regarding Johnson's conduct in high-profile investigations, including the Smollett investigation where Johnson has misled the city and the public. Finally, the city's protest that it has already produced over 11,000 pages of responsive documents is in no way indicative of the thoroughness or completeness of its production. The overwhelming majority of the city's production to date are summary reports from the investigative file, including inventory and responses to warrants or subpoenas. It is bereft of any of the internal documents, communications surrounding those reports and materials, which are part and parcel of the discovery in civil litigation. Even if the city is correct that Johnson's involvement with the Smollett investigation involved direct reports, documents or communications evidencing as much have not been produced. The city should not be rewarded for withholding responsive materials in a lawsuit it initiated. We knew this was going to happen. We talked about this in previous vlogs. Jussie Smollett's strategy is going to be to burn the place down. Expose CPD misconduct or incompetence, even if it doesn't relate to Jussie Smollett, to deter the CPD from pursuing their claim against Jussie Smollett. And the reality is, like we've also talked about in previous vlogs, litigation is a two-way street. You don't get to sue someone and say, I'm not allowing you to discover anything about me. When you sue someone, you open yourself up to discovery because the defendant is allowed to defend themselves. And in their defense, they are going to want to discover documents from you, and you may not find these documents relevant, but it is not up to you to build the defense of the defendant. Relevance is construed broadly. If the defendant thinks the documents might be relevant, the defendant can compel production of those documents. And unless there is an overriding principle, production of those documents will be compelled. The findings of the investigation and termination of Johnson are unquestionably relevant to Mr. Smollett's defense, and similarly situated public officials have been compelled to produce documents and even testify after publicly speaking on related matters. Mr. Smollett's request for production of documents concerning Johnson's termination is relevant because it strikes to the serious issue of the city seeking the prosecution of someone they knew to be innocent. Again, because I know a great many of you are probably swearing to yourselves right now as you listen to this, we are in the court of law. Nothing has been proven as legal fact in the court of law. Even though all of us out there are pretty much thoroughly convinced in the accuracy of what we believe in this particular situation. But that is not a court of law. In its opposition, the city improperly attempts to argue its case and focus on trial admissibility in a discovery dispute. That is not the law. Matters relevant to a party's defense need, quote, not be admissible in evidence to be discoverable. The city has not claimed the requested documents are privileged, and the city cannot show that Johnson's lack of truthfulness while acting as superintendent of Chicago police is not relevant to the subject matter of the pending action. And this highlights a critical distinction between admissibility of evidence and discoverability of evidence. Admissibility of evidence comes at the trial or at the hearing and is determined by the judge. Discoverability comes well before that at the discovery stage. And just to take a concrete, if albeit oversimplified example. In a lawsuit for bodily harm, for example, you ask one of the parties if they have any pictures of the incident. They could not say, yes, I have pictures of the incident, but I didn't take those pictures, therefore they're not admissible as evidence, so I'm not communicating them to you. They may have that argument before a judge, they may raise that argument before a judge, but the admissibility of the photographs is different than the communicability, the discoverability of those photographs. If they have those photographs, they can be compelled to produce them and they can dispute the admissibility of those photographs come trial time. Mr. Smollett's discovery request is relevant because it is germane, and any argument by the city that the request must be, quote, competent or, quote, admissible is without merit during this stage of the proceedings. The city attempts to distract from the issue of relevance during the discovery by focusing on the potential admissibility at trial of Johnson's testimony. This is not the standard during discovery, which instead looks to whether the information sought is relevant to the subject matter of the action. And here by the sounds of it, it sounds like the city of Chicago is saying we're not going to communicate to you the documents regarding Johnson because you can call Johnson to testify as a witness come trial time and you can compel him to bring the documents come trial time. The obvious response is going to be, sure, Jussie Smollett can do that, but he wants to build his defense before trial, not at trial. Obtain communication of the documents at the discovery stage so that Jussie Smollett can see if it's relevant to his defense of the action taken against him by the city of Chicago. Because the city cannot show there is no possibility the information sought by Mr. Smollett will be relevant, the city must comply with the discovery request. A request for discovery must be complied with unless it is clear that there is no possibility that the information sought may be relevant to the subject matter of the litigation. Due to, quote, the broad construction given to discovery requests, the city has, quote, a heavy burden to show why discovery should be denied. The city has not and cannot meet this burden. Whatever you might think or feel about Jussie Smollett, he is raising a tenable argument in law right here. And in conclusion, his attorneys write as follows. As noted above, at this stage in the proceedings, Mr. Smollett is not required to show admissibility, but rather the burden is on the city to show that the discovery request is protected by privilege or irrelevant. The city has shown neither and instead has improperly focused on the admissibility of the documents and the likelihood that Johnson will be called to testify at trial. This is simply a red herring. The law is clear. A request for discovery should be considered relevant if there is any possibility that the information sought may be relevant to the subject matter of the action. And here Mr. Smollett's discovery request directly relates to the subject matter of the action by implicating the city's maligned response to his report of a vicious hate crime and assault. Wherefore, for the foregoing reasons, defendant Jussie Smollett respectfully requests that the court grant the motion to compel and any further relief that the court deems just. This motion perfectly illustrates that no matter how strong your case is in law, the litigation process itself is a dirty fight. A plaintiff who decides to sue does not get to control the litigation process. They do not get to say you can discover certain things but not other things about me. Once you sue, you are sort of opening yourself up to this type of attack. You are opening yourself up to airing your dirty laundry to the world. Jussie Smollett knew it. We talked about it and I called it from the very beginning. Jussie Smollett is going to make this a dirty, dirty fight for the city of Chicago. He's going to make it dirty. He is going to make public things that he doesn't think the city of Chicago wants to make public in the hopes that they're going to drop the lawsuit and give up on pursuing it against him. He is going to take the fight from the court of law to the court of public opinion to try to publicly shame or embarrass the Chicago Police Department. I don't think it's going to prove to be a winning strategy, but at the very least, on this motion to compel the production of documents, I do see Jussie Smollett succeeding. He's going to get documents. They may or may not relate to his lawsuit. They may be embarrassing for the city of Chicago. He may file them in the court record so that they become public and thereby embarrass the city of Chicago. And that is unfortunately one of the many dirty strategies of the battle of litigation. It is a dirty, dirty industry. All right, and with that said, I hope you have a bit more of an understanding of the situation. If you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. It feeds the algorithm and helps my channel grow. If you want to support the channel, all of the support links are in the pinned comment. We've got merch, PayPal, subscribe to our Patreon, but above all else, take care of yourselves, check in on friends and family, and make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah!